Welcome to What's Over More or Less. My name is Jason, and today I have a thought for you on on the Constitution that I'm going to kind of title based on a book I got back in 2019 or 2020. Nilla, Sunday. Leave it alone, buddies. Um, my crazy guard dogs here. Um, Anyhow, the book is entitled "An Enemy Hath Done This." It's by Ezra Taft Benson, and back in about I want to say around 2010 or so, 2009. I was in my 30s. I was attending college. I had gone on my mission when I was 25. I should have served under Ezra Taft Benson. Instead, I had served under Gordon B. Hinckley, and just wanted to be a rock star when I was a kid during the Ezra Taft Benson years, and so didn't pay enough attention. And so suddenly I'm like learning all this stuff that I used to just completely ignore, that used to kind of annoy me. And I still hadn't caught up on the Ezra Taft Benson years. I knew that I loved Gordon B. Hinckley and James E. Faust and everybody else. And I knew I loved the ideas of personal accountability. And I'm taking all these classes at ASU. And supposedly I'm going there to become a respectable person with better ideas. And they were driving me crazy. I couldn't believe some of the ideas they were teaching me. I was like, this isn't very enabling thoughts at all. And I happened to run into at the time, I think either the talk Stand Up for Freedom by Ezra Taft Benson or It Can Happen Here, something to that effect. And I was like, oh, the world makes sense again. And so suddenly Ezra Taft Benson, who I had ignored during the years I should have been really paying attention to him, was there for me to pay attention to him. And I'm like, wow, this is great. So, but I had life to get on with. I was still trying to catch up for years of not going to college when I should have, not finishing my high school diploma, getting my GED, all that kind of stuff, and going to my 30s to college. And so I didn't get super into it at that time. I just kept it in the back of my mind and would occasionally go and look up Ezra Taft Benson talks on YouTube or something like that. Then around 2019, 2020, I'm with my wife at the thrift store. We see two books that grab my attention. I'm like, we're going to need these books one of these days in the future. One of them is called The Lord's Way by Dallin H. Oaks, and one of them is called An Enemy Hath Done This by Ezra Taft Benson. This is at DI, Desert Industries, not a Desert Bookstore. And so I grabbed them. I read The Lord's Way first, because I still wanted to stay off of the political topics, which, when you really think about it, President Benson wasn't political. He was teaching principles and the Constitution. He wasn't teaching politics. And so, anyhow, here's the concept. In that book, he has a chapter titled something like Judicial Oligarchy, or the Tyranny of a Judicial Oligarchy, something like that. Which harkens to a quote, a letter from Thomas Jefferson. I can't remember who it's sent to, but he says, if it were ever true, because he had later on found out, I think, what Alexander Hamilton had claimed in Federalist 78, which isn't part of the Constitution. Hardly anybody even knew it back then. And this was in the later years. He says, if this idea is true that Hamilton put forth, it would make the Supreme Court an oligarchy, a judicial, a tyranny of the oligarchy, something to that effect. And again, the name of the book by Ezra Taft Benson is called An Enemy Hath Done This. Now, that's not the main focus of the book, that particular chapter, although I think it needs to be paid attention to. And I'm going to come to it here in a few. We have to remember that Ezra Taft Benson told us we're expected to defend the Constitution, but that the church won't tell us every way that we're supposed to be defending it. So this is me taking the initiative then. And An Enemy Hath Done This harkens back to Jesus telling the parable of the farmer who plants the good wheat seed in his fields. And then next thing you know, an enemy comes behind him when he's not watching and plants tares. Now, tares are seeds that bring up something that looks like wheat. They think it's probably darnel, and it's related even, but apparently it tends to get a fungus on the seeds that's quite bad, that's quite poisonous, causes you to hallucinate, things like that or something. Anyhow, but at first it looks like wheat. It looks like it's part of the wheat. Now, I'm going to point to what happened early on in the Constitution, which I think the Constitution was amazing seed. If you look at Frederick Douglass and Lysander Spooner, who came along later on before the Civil War and after the Civil War, They spent years studying it, and by the time they were done, they said, "Oh no, the Constitution's perfect the way it's written. We've just been applying it wrong." I am going to 100% agree with them, and you will not get this if you go to standard law school training. You just will not get it. Your thought process will be corrupted. You have to spend more time with the Constitution than you do with other stuff. So the enemy seed that was planted early on, that looked like it was part of the Constitution, but it's not, is what we call judicial review. Happened first with a case called Marbury versus Madison, where John Marshall, the Chief Justice, admits, hey, the courts don't have the power to do this or intervene in this or that, right? But at the same time, he makes a claim in the majority opinion, or however they did it, saying that it is clearly the duty of the Supreme Court to say what the law is. Now, that's inconsistent with what courts were understood to be back then. They would have been responsible under, say, for example, the Montesquieu view to pronounce what the law is that's relevant to the case, but not to say what the law is, but to pronounce it. This is the law that's relevant to the case. They would have been responsible, according to their oath, to analyze the supremacy of the Constitution versus the law and see if the law was in conflict. And then, according to their oath, say if a law that they were supposed to be enforcing actually contradicted what the Constitution allowed, then to say, I can't enforce this law in the first place. I can't even hear the case because the law violates the Constitution. That wasn't ever to be a binding opinion on all other oaths of office. There was no parameters put into what judicial review was supposed to be. There was no procedure for it. It wasn't listed in the hierarchy of the supremacy clause, which is the Constitution, then the laws through the Article 1, Section 7 process, and then the treaties through the Article 2, Section 2, Clause 2 process. It wasn't there. But it looked like the Constitution, perhaps because of the introductory phrase to Article 3, Section 2, which says the judicial power of the United States. It doesn't even say the Supreme Court's power. It says the judicial power of the United States shall apply to all cases arising under this Constitution, laws and the treaties. I'm probably saying it slightly wrong. In law and equity, right? And so it's kind of an instructive. It says law and equity, and then it turns around and enumerates cases, the types of cases over which the courts would have jurisdiction. Clarifies then which courts will have which jurisdiction as appellate jurisdiction versus original jurisdiction, right? But John Marshall made it sound like the word judicial in and of itself meant someone who says what the law is, but that's just not true. And there was no way to make that binding on the oaths of office of others. However, what began to happen, and this is what Jefferson complained about, is people began to take him seriously. So you get these cases. This is where the problem is. So that looked like the Constitution, but it wasn't the Constitution. The problem that occurred is then he starts deciding cases or rejecting cases. In Barron v. Baltimore, Fifth Amendment violation, deprived of property without due process of law by his state. Lawyers think it's a serious case. They bring it before the Supreme Court because that is one of the kind of cases that's towards the end of Article 3, Section 2, that says that kind of case can be brought before the Supreme Court. And John Marshall says the Fifth Amendment is part of the Bill of Rights, and the Bill of Rights is only restrictions on the federal government. It is not restrictions on the state governments. That can't be true. That cannot be true. The whole Constitution is constantly referencing powers to the states and power to the federal government. Of course, John Marshall's logic is that it should have been clarified, but it wasn't clarified. The First Amendment is clarified. If you want to look for a pattern, the First Amendment is clarified. It's a restriction on the federal government only. Amendments 2 through 9 are prohibitions on all levels of government. That is the only reasonable conclusion. That's what Frederick Douglass came to. That's what Lysander Spooner came to. It's what Madison would have said. It's what Jefferson would have said. Yet Marshall comes along and says, because of the original history, that it was the anti-federalists, who wanted the Bill of Rights, and they wanted to control the federal government. That's not true either. I think that's the way he said it. It's just not true. If you read the The Second Amendment. Let's go with that one. Militia, well-regulated militia being necessary to the rights of a free people. I think something like that. The rights of the people to keep and bear arms shall not be infringed. Which level of government did it say? Which branch of government did it say? Did it say Congress? Did it say federal government? Did it say state governments? No, it didn't say any of that. It's an all-out prohibition on everybody. Nobody can infringe on the right to keep and bear arms. That is literally the plain text. Nobody can deprive somebody of life, liberty, or property without the due process of law. That is literally the meaning of the plain text. These are standard privileges and immunities. But anyhow, in Barron v. Baltimore, and also in a Johnson v. something, this is a Native American case where the Native Americans were trying to claim the right to their land. John Marshall again said, hey, they can't own the land and they have no rights. It can't be their property, something to that effect. And again, he deprived. So this is my first complaint is after the fruits begin to come out, and that's where you begin to know the tares, is he's taking rights away from the people, or he's failing to defend rights where he should be defending rights. Then my second complaint is McCullough v. Maryland is a perfect example. McCullough v. Maryland is the banking case, and I'm not an expert on the case. I intentionally try to avoid studying judicial precedent because, to me, that's the fastest way to corrupt your understanding of the Constitution, because it looks like Constitution, but it's not Constitution. And McCullough v. Maryland, the Constitution did not grant the federal government power to establish a bank, but they wanted to do it anyhow. And John Marshall came up with some explanation for the necessary and proper clause, and suddenly, boom, he substituted this word with that word, etc. And boom, all of a sudden, establishing a national bank was justified. So my two main complaints about the fruits is the failing to protect the rights of the people. The courts have continuously failed to protect the rights of the people from the beginning, and the failure to limit the powers of the federal government. They have continuously failed to limit the powers of the federal government from the beginning. And then my complaint that comes even prior to that is it's not even in the Constitution. It's not even something they can do. There's everything that's binding in the Constitution has a procedure with a threshold. It's just not there. It sounds like it's part of constitutional law. 75% to 90% of what you study if you take a constitutional class as a lawyer, they're going to be teaching you judicial review more than they're going to be teaching you the actual Constitution. I've listened to several lawyers recently who say, and some of them went to British schools before they came here, and they said, the system for educating people on the law is so much better over there because all they do is obsess over judicial review here, and which makes you stupider regarding what the Constitution actually is. And so they say you'll be better at understanding the Constitution if you don't go to law school. Sorry, I shouldn't be laughing at it. It's actually quite annoying, but okay, so the enemy's seed is clearly judicial review. It looks like it's part of the Constitution. It looks like it's part of Article 5. It's not part of Article 5. It's not even part of Article 3. It's not part of Article 6. It's not part of any of it. And so if I'm a farmer and I've got somebody who's planted tares in my field of wheat, and I want to fix those tares, I want to get rid of them and fix the wheat and protect the wheat, am I going to go plant more tares to fix that? No, I am not. This is the most common sense thing I can think of saying. In other words, if you're waiting for the Supreme Court to come along and start striking down all of its bad judgments, which I understand like 99.9% of the time a law is challenged as unconstitutional, the Supreme Court just lets it through anyhow, right? That's not good. That's not a very good record. Do not wait for the overturning through the same route that created the problem in the first place. The Mormons would not have been run out of Missouri had it not been for Barron v. Baltimore. A plain reading of Article 4, Section 2, Clause 1 should have said that these immigrants to Missouri should have been protected. But Marshall had already established this doctrine that the Bill of Rights only applied to preventing the federal government, not the states themselves. What a load of baloney. The idea that the judicial branch is meant to be the final word of the meaning of the Constitution. Jefferson claimed otherwise. Jefferson claimed, okay, we have to carry out the sentences, the executive branch does. You guys give the sentences, we have to carry them out. But if we look and see that the law that you sentenced them based on is unconstitutional, we can actually remit the sentence. So who's the actual final word? It's the president, apparently, according to Jefferson, and that makes sense. The ultimate pardon power is in the president. The take care clause is in the president, which is really weird, but that's what it is. Honestly, if you read the Constitution, the take care clause, in other words, if anything's off in the way things are being carried out, the executive branch is to execute the law and stop the violations of it, okay? Not the Supreme Court. The Supreme Court is only supposed to be making decisions, passing sentences, making judgments, and they in no way whatsoever apply to Article 6, Clause 2. So they are, as far as I'm concerned, the enemy seed. And even though the book An Enemy Hath Done This only has one solid chapter totally dedicated to them, it's just obvious. If you're a Dallin H. Oaks fan, let me tell you something. I'm getting ready to do a video on Dallin H. Oaks real soon here. Hopefully he doesn't mind me saying this. I think I'm right, though. He is a genius. He is so smart. His rhetorical tactics for getting around the uncomfortable issues and cutting to maybe some deeper philosophical issues is awesome. I have yet to see him confirm that judicial review is a good thing, that it's the way the Constitution was meant to work. I've seen quite the opposite from him. I've seen him trying to be a peacemaker and trying to plead with people to stop resorting to judicial review for everything. The winner take all. Stop it. It's psychologically bad. When supposedly Roe v. Wade was overturned, which it was never constitutional in the first place, why did it need to be overturned? There was like all this psychology on the side of the left. They were so mad at the right? The whole time, the whole thing was unconstitutional in the first place. It wasn't even the prerogative of the federal government to be involved in deciding abortion or not. As a matter of fact, if anything, it's always been the prerogative of the federal government to protect people from deprivation of life if the states are failing to protect them from it, right? In the end, it's the privileges and immunities. I guess, though, when you're dealing with a body inside another body, it complicates things. But so yeah, President Oaks has exhorted us to stop looking at the winner-take-all thing. He's found the interpretations of judicial review of the Constitution through the judicial branch uninspired. While he's complimented amendments, read them, pay attention. He's rhetorically a genius. The cases where he points to the Kim Davis case, I'll be talking about that one more, but I think the fact that he picked that one case where some government official used her First Amendment rights supposedly to impose those on somebody else, on somebody else's Ninth Amendment rights, yeah, it's a perfect case for like throwing somebody that seemingly is on your side under the bus, right? And which I can't remember what that rhetorical tactic is, but I've got all these rhetorical tactic names that I've been looking up because I'm like, he says very interesting things that if somebody's not paying attention, they will miss it. And they will think, oh, he believes in judicial review as though it's like a really good thing. I'm 90% sure. If you know him, ask him if he agrees. I'm 90% sure he doesn't. Like, he consistently doesn't. So, what's the enemy seed? It's judicial review. So, and you can't fix judicial review with more judicial review. Enemy seed will not suddenly start bringing you wheat. It'll always bring you tares. See you guys.